All right, let's see. Okay, there we go. All right, so as Lucy laid out, the Utilities Commission is the regulator. The public staff is the consumer advocate. They appear in front of the commission. Here, I'll show you some pretty faces. So they appear in front of the commission as a party, just the same as the utility, an environmental advocate, a particular consumer group might. Um, but this group, we now are back to a full complement of 7 commissioners. The down on the bottom row, Commissioners Duffley and Hughes finally took their seats in November of last year, and Senator McKissick joined us in January. We were operating with only 4 commissioners for quite some time as the General Assembly got around to confirming. So our commissioners serve 6-year terms, used to be 8, now they're 6-year terms. They are nominated by the governor and confirmed by the legislature. Um, I guess in the past, things possibly weren't as political as they have become over the last 5 or 10 years. And but even when the governor and the General Assembly were the same party, the General Assembly has been sort of exerting its influence more recently, and so that has shown itself up for us in terms of delaying confirmation of the governor's appointees. But we're finally back to a full complement of 7. Uh, and so let's see, I need to minimize your picture here. There we go. There we go. Okay. All right. So as I indicated just a few minutes ago, really, so the Utilities Commission is an economic regulator. We are a substitute for competition. One of the things that has come up recently, we've been talking about electric transportation. The utilities have filed a proposal for electric vehicle infrastructure. And so you think about what are typical competitive markets. Corner gas station. I mean, if I need gasoline for my car, I actually have a handy little app. I can sort of search now virtually instead of having to drive all over town. I'm in Raleigh, and I know generally where the cheaper stations are going to be. But if a gas station tries to raise the price of gasoline, it's going to find that it will sell less because the station down the street didn't raise its price or didn't raise its price as much, and so people very easily shift from one supplier to another to purchase that product. So here for electricity, we've decided over the last 100+ years that we are best served by monopoly regulation for electric and gas and some other utilities. And so we have to have economic regulation in place in order to prevent the monopoly provider from setting the price, because clearly its interests are not always aligned with that of its customers, since the customers are captive and can't go anywhere else. But we're not single-minded in terms of setting rates that are the best rates for customers. We have to balance those interests of the utility, who has the obligation to serve, and the utilities who are being served, and the customers that are being served by these companies. All right, going to go back to, okay, there we go. So Lucy talked about how we established rates. The formula is actually set forth in the statute. So it's pretty straightforward to go to Chapter 62, the Public Utilities Act, and it says, here's how you set rates. You look at the amount of investment, the rate base, you determine a return on that. You look at the expenses that the company incurred, and then that gets you to a revenue requirement. So it sounds pretty straightforward, but in fact, it turns out to be a relatively lengthy and complex process. One of the things we're required to do in rate cases, again, under the statute, is to go out and hold hearings in areas that are served by the public utilities. So for Duke, for example, we might hold 4 or 5 hearings throughout their service territory. Rather than trying to make all of the customers drive to Raleigh just so that they can be heard, we will go out into the communities and we'll hold hearings. If it's DEC, we might hold hearings from Charlotte up through Greensboro, High Point, Durham, something like that. If it's in progress, we'll go out to Asheville, we'll hear something in Wilmington, we'll do one in Raleigh. So we'll spread those out, hold 4 or 5 hearings in each of those cases, and that allows customers. Now, you know, the testimony that we get from customers varies depending on what kind of utility that we're going out to hold a rate case for. And in the case of water utilities, we will typically hear about service issues. People will bring in jars of dirty water and complain that, would you drink this stuff? In the electric case, it's usually more focused on the utility portfolio, you know, and in addition, just folks think that Duke's making plenty of money and they don't have plenty of money, and the customers don't have plenty of money, so why should they have to pay Duke any more than they already are? I note here that most of our rate cases are heard by the full commission, so all 7 of them. Occasionally in small water companies, the statute allows us to assign a panel of 3 commissioners or even just a staff member to go out and take care of that. Lucy mentioned the 270 days. The first thing that happens is that the utility tells the commission, we intend to file a rate case. They have to give us 30 days advance notice, and then they file their application, which includes testimony of expert witnesses. For the utility, it's usually lots of internal company people. You know, they might have a dozen different people testifying about all different aspects, because again, this is a general rate case, so we're looking at every aspect of the utility's operations, and extremely detailed work papers getting to the bottom line. Then again, following the requirements of the statute, we declare it to be a general rate case and we suspend the rates. Rates are allowed to go into effect 30 days after you file your application. But clearly we can't do a rate case in 30 days. So we suspend those rates for an additional 270 days. And that gives us effectively 10 months to consider and decide a rate case and issue an order establishing rates going forward. So during that time, again, the utility has filed its application, and then other parties will intervene. We'll typically have customer groups of industrials. We might have low-income advocates. We might have environmental groups. More and more, we're seeing environmental groups intervene in utility rate cases. At some point, those interveners all have to file their testimony presenting their side of the case to the commission. Oftentimes, they will engage in negotiations, and we will get typically partial settlements, although occasionally we might get a compromise worked out between the utility and the public staff and one or more parties. And so then we hold a hearing. And right now, hearings might run anywhere from 2 or 3 days to 2 or 3 weeks. We have a water company case in front of us that I expect the hearing to run for a week or two. We have the Duke Energy Carolinas and Duke Energy Progress rate cases in front of us. Each of those would have likely run a couple of weeks, and the parties have asked us to try to consolidate those to make them go a little faster. They've all been delayed due to the stay at home and limitations on the COVID-19. But once we kick that off again, those consolidated hearings may run for 3 or 4 weeks. So during that hearing, basically all the parties, we don't do Perry Mason style hearings where everybody, where there's the commission sits as a jury and there's smoking guns and we're surprised by what we hear. All of this is done at the commission, an administrative agency, through pre-filed written testimony. So everybody is aware of every other witness's testimony long before we get to the hearing. At the hearing, the parties spend a few minutes, hours, days, challenging the testimony of the other party's witnesses, trying to discredit it and eventually be able to say, my witness knew better than your witness, so commission, you should believe our witness and not their witness. So after the hearing, the parties are afforded an opportunity to file what we call proposed orders and briefs, and the commission staff reviews that, presents the case to the commissioners for decision, and at long last, the commission issues an order establishing new rates going forward that the company then puts into effect. And then I have a note down there at the end that says, because these things take a while, the utilities are actually allowed 6 months after they would have gone into effect. They're allowed to put rates into effect subject to refund. So if the commission ultimately determines that lower rates are just and reasonable, then the company would have to refund the difference between that. So inevitably, somebody is unhappy with the commission's decision. I had a chair who used to say that if we make everybody equally mad, we're probably doing our job. So rate cases are appealed directly to the North Carolina Supreme Court. The other decisions by the commission are appealed first to the North Carolina Court of Appeals and then to the Supreme Court. But rate cases go directly to the Supreme Court. And I've listed there a number of grounds for appeal. Again, these are all set forth in Chapter 62. And so we have to write very long and detailed orders in order to convince the court that the commission actually based its decision on evidence in the record, on substantial, competent evidence from the witnesses, and that we were not arbitrary or capricious. And then that takes a while longer. Let's see, you're sharing this screen, stop sharing. Okay, all right, so the Duke Carolinas and Duke Energy Progress hearing rate cases that we heard 2 years ago got appealed to the Supreme Court, and we are still waiting on the decisions from the Supreme Court, and may have to revisit those decisions when the Supreme Court finally hands down its decision. Parties were variously not happy about the commission's treatment of coal ash in those two cases. And there were plenty of other issues, rate of return, basic customer charge, some other things that folks didn't like the commission's decision and wanted a chance to convince the court that we were wrong. Of course, we're never wrong, but the court doesn't always see it that way. So with that, let's see, I see, well, I don't see any questions yet, but I think I've still got just a few minutes on the agenda here, and so I'm happy to try to answer any questions you might have.
Stan, this is David. I'm going to encourage folks to unmic in a minute and ask you a question or pose it through chat. But I'm just going to ask you to explain another detail, and that the commission doesn't make stuff up. As I've come to understand commission operations throughout the various states, the commission is there to implement the policy that's been adopted by the General Assembly. So you might just chat on that just for a second, because I think often the people look at the commission and say, well, why did you decide that? Well, a lot of times very strict provisions are handed down by the General Assembly.
Well, absolutely. We are a creature of the legislature, and we tend to say that we don't make policy; we implement the policy established by the General Assembly. Now, I mean, we do have quite a bit of latitude and discretion, and we fill in a lot of gaps in the statutes that are handed down. But ultimately, what the commission's trying to do is to interpret what we believe the intent of the General Assembly in adopting that legislation. So, whether we're doing the renewable energy portfolio standard and filling in blanks in that and implementing it and reporting to the General Assembly, or doing a general rate case. And again, everything that we do is, I guess, a part of the checks and balances. Everything that we do is subject to review by a court. Keeps us honest, makes sure that that we are appropriately interpreting the statute and following the direction of the General Assembly. All right, so you want me to answer this question? Have you seen any potential impacts on the current rate-making process for DAP as a result of COVID-related expenses or lost revenue? Have you seen any potential impacts on the rate-making process? So, the primary impact that I expect at this point, well, there will be a couple of them. I mean, one of them is just, so I was going to say loss of load, and I believe that the energy sales might be down overall for Duke. But keep in mind, though, that even though people aren't going to the offices, they're all still working from home. So industrial or commercial sales might be down, whereas residential sales might be up. I mean, I know on the water side, there's actually water utilities that are seeing increased revenues as more people are staying home and working at home. One of the more visible, though, perhaps, is the moratorium on disconnections. There was an interest in, as businesses were required to close and people were laid off temporarily or otherwise, the citizens might have been having to make do without paychecks. A lot of folks were living paycheck to paycheck anyway, and if your restaurant was forced to close and they didn't need you to come in as a server anymore, then they generally weren't going to pay you not to work. Some of us, I'm sure many of you, were fortunate enough to be able to take your work home. I'm set up here, and I found a little corner in my house to set up a home office, and I've been working quite a bit. But a lot of the citizens in North Carolina were not so lucky, and so we didn't want to compound that by having the utility disconnect them for service. So we sort of shifted that burden of the virus from individuals to the utilities, who hopefully were in a little bit better shape to be able to handle the revenue loss. So what we've got is we've got a lot of customers that are falling behind on their utility payments, and the utility is not allowed to disconnect them like they normally would. We all in our utility bills pay just a little bit every month to cover folks that fall behind and cannot pay their bills. The utility is allowed to disconnect them so that that amount doesn't get too high and doesn't impose, when it's not a welfare program. And so, we disconnect people if they can't pay their electric bills. But during the COVID and the state of emergency, we put a moratorium on disconnects. So the utility is, I expect there will be more and more amounts that people will find that they can't pay, so uncollectibles by the utility. And those amounts will probably have to be dealt with and spread out. The utility will they won't want to have to shoulder the entire burden of customers that couldn't pay. And that applies actually not only to you and me, residential customers, but there's a lot of, I don't know how some of these businesses are, rent doesn't go away, mortgage doesn't go away. And yet, if you're one of these businesses that was closed for a couple of months or may even still be closed, you don't have the revenues to cover your expenses, and utilities is just another one of those expenses. So we will expect folks to get back right with the utility. We will give them extended periods of time to repay those bills that they couldn't pay when they were out of a paycheck. But that's certainly otherwise. The utility in general, they may see some reduced revenues from reduced sales, and I expect that will just be handled through the normal rate making process, where they might have a dip in their earnings. And I haven't actually been listening in on the earnings calls that Duke has been doing, so I'm not sure what their current forecasts are for what they believe the impact of COVID is. But they will have an opportunity to request rates going forward to make them whole and to allow them appropriate earnings for their shareholders. I probably went on way too long with that explanation.
I thought it was pretty interesting, Sam. Thank you.
Well, otherwise, I'll just say, I know David right at the very beginning of the day went through his background, and you can generally be whatever you want to be. You're not stuck with what you're doing. In my career, I started out as an engineer. Unfortunately, I graduated back post TMI, so nuclear wasn't doing so hot at the time, and I ended up doing computer programming and designing executive information systems for 3 or 4 or 5 years. I had been doing nuclear licensing work during school, and then early before I went into computer programming, and decided that I wanted to do licensing work again. So I went off to law school and have been working variously in private practice, representing folks, worked at a utility, and now I've been working for the regulator for the last 22 years, quite some time. So I bounced around a little bit to get started, but now I've been with the state since '98. And So finally, I guess, found my niche, and enjoy it. But I mean, it certainly, it's not a requirement that you have the technical background to be a useful attorney in this industry. But I think that certainly helped me out, having the engineering background and then the utility service, to understand what the utilities are doing, and when we get issues brought to the commission, being able to sort of understand as a consumer, certainly one side of it, and but having worked at a utility, understanding the other side of it and trying to reach fair decisions for utilities and their customers.
Sam, we thank you. Excellent as always. And,
Well, and I sent you my presentation ahead of time, and you are more than welcome to share that.
appreciate that very much. So thank you, Sam.